to join us. And for those of you who don't know me, my name is Allison Held, and I'm the director of the Medical Legal Partnership at VCU. And we're delighted to have Sylvia Jones joining us today from Central Virginia Legal Aid Society to present on Social Security Disability Insurance appeals. So for those of you, many of you probably know that we, the MLP, can only take certain Social Security cases for full representation. In most cases, we can only provide advice. So we wanted to, and those exceptions, by the way, are, and Sylvia, correct me if I'm wrong, are Social Security overpayment cases and also children's SSI cases. So CVLAS can provide full representation in those cases, but otherwise we can only provide advice. So we wanted to provide this primer for you all, just so that you all have this information and can share it with your patients and can help your patients with these cases. If everyone could make sure you're muted, that would be great, so there's no background noise. I'm going to monitor the chat, and if you could put your questions in the chat, that would be great. I think Sylvia's presentation is about 30 or 35 minutes, and we'll leave time at the end for questions. And I think without further delay, I'm going to go ahead and introduce Sylvia. Let me pull up my bio. Oh, sorry. Sorry, just one second. Okay, so Sylvia joined Central Virginia Legal Aid Society on January 17th as managing attorney of the Richmond office. She comes to CVLAS after 16 years at the Legal Aid Justice Center, where she served as a managing attorney and director of professional development. Sylvia also served as a deputy attorney general over the Health, Education, and Social Services Division of the Virginia Attorney General's Office. A Kentucky native, Sylvia moved to Virginia in 1993, immediately after graduating from the University of Kentucky College of Law. And during her spare time, Sylvia enjoys playing the cello and is an active member of the Richmond Philharmonic Orchestra, a premier community orchestra that performs several concerts a year. So Sylvia, I'll hand it over to you.
Well, thank you. I need to try to share my screen, right?
Yes, you should be able to do that.
Okay, let me see here. Can you all see the presentation?
No.
Okay. Oops. All right. I might need a little assistance on how to do this. So if I go, I'm on the presentation now, but let me.
Yeah, so if you go to the Zoom meeting at the bottom, there's a button that says share screen.
Oh, okay. I am not used to Zoom. Let's see here. All right. All right, let me launch this.
Yes, we can see that.
Okay, all right. All right. Well, thank you for that introduction, Allison, and yeah, and thank you for my shameless plug for the Richmond Philharmonic. I had rehearsal last night, so I rehearsed on Monday night, so it's very tiring. But I'm glad to be with everyone this morning, and thank you for the opportunity to share some things about Social Security disability insurance. Allison mentioned that I was going to talk about appeals, but I'm probably going to spend less time on that, and I think someone had wanted some information on eligibility, and quite frankly, eligibility, you know, the better you prepare your case at the initial phase, the more likely you are to avoid an appeal. So I just wanted to spend a little time talking about that. I'm trying to stay within the 30 minutes. Social Security is a very, very dense topic, and I will point you to some resources that will hopefully, if you have any questions, will hopefully give you some more information in addition to contacting me if you have questions. Okay. All right, so the agenda for this morning is briefly. I'm going to give you a brief introduction, a lot of information, but brief introduction. I will give this presentation to Allison, so you guys will have it. But so introduction, eligibility for SSI, SSDI, and I'm going to talk a little bit about SSI because there's a lot of confusion around those two different programs. I'm going to talk about applying for SSDI and some of the snags that I've experienced since primarily the pandemic and coming out of the pandemic. Common issues for MLP clients, how CBLAS can help, and then I'm going to reserve some time for questions. Okay, I know there's a lot on this slide. This just to give you just a little bit of the history of Social Security disability. What this is just the beginning of a timeline from when Social Security was acted into law by President Roosevelt. August 14th which would have been 6 days before my birthday had I been born in 1935. So it's a pretty old program. And the red in the middle just denotes that in 1954, yes. The Social Security amendments. The Social Security initiated the disability insurance program that provided against against insecurity.
All right. I think we've got someone who needs to be muted. Yeah, there we go. Sorry.
I'm sorry. I just but just suffice it to say that this slide, basically, I just wanted to point you to this link down at the bottom. If you really want to just geek out on Social Security law, there's a nice 7-page information fact sheet that's dated in 2020, which is pretty fresh, that tells you about all of the amendments to the Social Security law and the disability law and just kind of how the program works. So I just wanted that resource to be available to you. Size and scope of Social Security disability. I want to point out that it serves a lot of people. It paid over 9.5 million folks in 2020. Most of those are disabled workers. About 89% of the awards were folks that were all disabled beneficiaries. And their benefits were terminated in this fourth bullet point. I just want to point this out that around almost 900,000 lost their benefits for some reason or another, and kind of this is where we hone in on another area of the law that we kind of assist with in some cases, because sometimes the terminations are for overpayment, sometimes they're for continuing disability review, where the Social Security Administration found that the claimant no longer was eligible. And then supplemental security income payments were another source of income for about 1 out of 7 disabled beneficiaries. Okay, and then the last thing with regard to the introduction, I just wanted to point out some statistics about the average, the profile of disabled workers. The average age was 55, so well below retirement age. Average monthly benefit was around $1,277, which is not it's not a lot of money, but it's something, especially for our client population who typically are lower income. So we want to try to maximize as much as we can for these clients and patients. Okay, so the definition of eligibility. So you have to have a disability, and this is probably the most powerful part of the analysis for determining whether a person is eligible for SSDI. It's a very short definition. You have to meet this definition of disability, but this definition packs a powerful punch. So it's basically first the inability to engage in any substantial gainful activity. I'm sorry, for some reason the folks are covering up the slide, so I can't really read it. with by reason of any medically determinable physical or mental impairment. That's a lot of words. And then the third element, which can be expected to result in death. And the fourth element, or has lasted or can be expected to last for a continuous period of not less than 12 months. So it's a time-limited analysis based on your ability to work, your medical impairment, and the passage of time. So eligibility for SSDI it's a 5-step process. And so the first step of the process is whether or not the claimant is engaged in what is called substantial gainful activity, or SGA. SGA basically is the level at which, if you're performing over it, then you are typically not determined to be eligible for SSI disability. This number, there are earnings over $1,350 a month. This number typically changes every year. It goes up slightly for cost of living. But if you earn above this month, if you earn above this amount, you typically are not going to be found eligible because you're engaging in SGA. To calculate that amount, sometimes the SSA will subtract things like your medical expenses, work expenses, to allow you to work because of your disability, which can lower it below the $1,350, and will give you an opportunity to maybe explain to the Social Security Administration that you're not earning or engaged in SGA. So this is really the first part of the analysis. If the claimant is not performing SGA, then if the claimant is performing SGA, then they're not disabled, and your analysis can actually stop here. If the claimant is not performing, then you go to the next step. Before we go to the next step, I just wanted to show you this little tool that I found on the SOARWorks website. And so as I said, these numbers kind of can tick up every year. So what this is just kind of a desktop quick facts. There's certain things like the SGA, what I circled is where I'm pulling that number from. So in 2022, the regular SGA amount went up to $1,350, went up a whopping $40 from 2021. Other things on here that are kind of helpful to me is the thing around SSI rates, which I'll talk a little bit about later on in the presentation. And then this other stuff up here in the orange is about work quarter requirements, which is another element that you have to meet to become eligible for SSDI. So there's other very interesting things here, like full retirement age, things like that. So this is just a really nice thing if you just want to be aware of, certain thresholds, especially in 2022. Okay, so step 2, does the claimant suffer from a severe impairment? It's not a severe impairment if it does not significantly limit your physical or mental ability to do basic work activities. One thing that I've typically find is that physical impairments are a lot easier to get approval on, just because they can be more medically determinable than things like mental, like anxiety and depression and things like that. Sometimes hard to measure how that affects your ability to work, but it must be medically determinable, which can be shown through lab results, x-rays, really, really good continuous medical evidence that doesn't have gaps, that shows that the patient was compliant with medications and things like that, that despite all of their best efforts to work, these medical impairments just does not allow them to work full time. The other requirement is that the impairment must be expected to last 12 months or result in death. if there's an appeal to an administrative law judge, the testimony of a medical expert is often needed to determine whether or not the impairment is severe enough. So if the claimant does not have a severe impairment at this point, then they are not disabled and the analysis can stop here. If the claimant does suffer from a severe impairment, then we're kind of part of the way there, but we still have to go to another step. And that's step 3. The third step is, does the impairment meet a listing? So there are 2 types of listings. There are adult listings and child listings. And that's because they're just different thresholds, and children can be found eligible for under a different program, SSI, and sometimes under SSDI if they are on their parents' record and are disabled. But if you go to these links, there's a listing, there's a nice landing page of impairments that are broken out, and I'll show you in the next slide. But if the client meets or equals a listing, then the claimant can be found disabled. If it does not, then we have to go to the next step. And let's just talk a little bit about listings. This is where it gets a lot more complicated in the analysis. If you go to one of those links, if you go to the adult link, you'll see that there are several categories of impairments. And I have a hard time pronouncing musculoskeletal disorders, which in one of the slides in the beginning, that was like one of the highest areas where folks were found disabled. And then there's, you have all the way to the 12.00 mental disorders, immune disorders, cancer, malignant neoplastic diseases. And you almost have to just figure out what impairments fall in this category. Sometimes it's very obvious, sometimes it's not so obvious, especially if you're not a medical expert. So let's say that we drill down into the 1.0, which is the musculoskeletal. There's a long listing of different impairments underneath that. And what I did was scroll down all the way just to pick one that was a bit shorter, because some of these listings can be very long and you have to really meet all of the things that the listing requires. And one thing I can say about the Social Security Administration is that, first of all, they have a really, really great website, ssa.gov, and they spell things out pretty, I'm not going to say it's easy to understand, but it is very logical if you just stick with it. So in this step, does the claimant meet a listing? So this one is for pathologic fractures due to any cause. And so you have to, ands mean ands and ors mean or. So you have to meet A, and then you have to meet B. But under B, you can have some options. You have documented need for a walker, bilateral canes, crutches, and this, this could affect your ability to work. So if you meet this listing just on its face, then you are going to be found disabled. Now, there's sometimes when you don't necessarily meet it, because this is very, very prescriptive and hard sometimes to meet, word for word, or even, just categorically. So sometimes we can argue that a claimant equals a listing, which, is just kind of, it's, you're so close to meeting this, but instead of requiring a walker or a cane or crutches, you might have to have someone to just take you somewhere, which, it's just, if it were added to the list, then you would really meet the listing. Everything else is, very close in terms of, meeting all the requirements. So this is just an analysis, and you can imagine if there's, with all the different impairments that a person can have, going through this listing process is a very time-consuming and tedious thing. And it really should, have the consultation of the doctor to kind of help hone in on these requirements. You can give the doctor a form and have them fill out you know, how severe the impairment was, and you know, does it meet these particular listing requirements, depending on the listing. So this is just one example. Step 4, assuming you don't meet a listing, is the claimant able to perform past relevant work? And again, this is often going to require, if you're, you know, before an administrative law judge, this is often going to require testimony of a vocational expert. And what does the SGA count? So they'll count 15 years of past work. The biggest thing is unsuccessful attempts to work. And if you can show a judge, you know, I tried to work, but it just, this impairment just gets in the way, that helps to determine whether that person can perform SGA. The next part of that question is there residual functional capacity? So what can the claimant do? Take, for example, let's take a surgeon, for example. So a surgeon has to have steady hands, the ability to stand, and, you know, definitely some mental capacity in order to perform the surgery. But if something happens and that surgeon can't perform, then, you know, the question is, well, can he or she perform other skills? Well, you know, they may not be able to perform the surgery, but can they assist or review medical documents leading up to the surgery? So these are questions that are often asked and considered when determining whether a person or a claimant can perform residual functional capacity. And they take into account the age, education, experience level, skill level, and whether there are transferable skills. If the claimant can perform past relevant work, then he's going to be determined not eligible, not disabled. And if the claimant cannot perform past relevant work, then the next step, step 5, the final step, comes into play. Step 5 is the claimant able to perform other work. Again, like the last step, vocational expert testimony is going to be likely required. This is because the Social Security Administration has the burden to prove that the claimant can perform other work. And the really difficult thing about this part of the analysis is that oftentimes the vocational expert will go off and find a list of jobs that exist in the national economy that person can do. And it doesn't really take into account whether the employer there are employers in the area that they're talking about, or whether the employer would even hire that claimant. It's just whether those jobs exist in the national economy. So a lot of times a very aggressive vocational expert will say, no, there's these jobs that this surgeon can do. And so they can transfer into other work. So if the claimant can perform other work, then they're not going to be determined disabled. If they cannot perform other work, typically they're going to be considered disabled. Now, there's a lot of other considerations that, you know, if you do Social Security work a lot, you know how to try to finesse this, because there's the grid that really considers age and the ability to successfully transfer into other work. So the long and short of that is, the older you are, the easier it is going to be what's called gridded out, and you won't really be required to perform other work. And then you can be determined disabled. Okay, so I wanted to talk a little bit about the intersection of SSI and SSDI. So again, there are 2 different programs that are administered by the Social Security Administration. They have a lot of similarity, especially the proof of disability. Both programs require you to be disabled. Both of them require that you don't earn above the SGA amount. The difference comes on the SSDI side. It's an insurance program. So it's kind of like your Social Security retirement. The more the more work you've done and paid into the system, the more money you can make if you're determined disabled up to a certain point. On the SSI side, SSI is more of income-based evaluation and resources. So if you have income over a certain amount or resources over a certain amount, you just don't qualify for SSI. And I just wanted to show in this slide that there is a population of folks that receive both SSDI and SSI. So this is the most confusing part of really distinguishing between these two programs, because the way that they're branded by the Social Security Administration is very, very misleading. And I always tell clients the I at the end matters, because the I on the SSDI side denotes that it's an insurance program. On the SSI side, the I means that it's an income-based program. And it's similarly confusing with the SS. On the SSDI side, SS means Social Security. On the SS on the SSI side, and I'm having a hard time saying the differences because they sound so much alike, but the SS is supplemental security. So there's a 5-month waiting period on the SSDI side. There's no waiting period for SSI. So a lot of times the reason why you'll have these concurrent enrollments is because of the 5-month waiting period. A lot of times we advise clients to go ahead and apply for SSI if they are not making any money, and see if they apply. You know, if they can get it. If they can get it and wait for the 5-month period, they could also apply for SSDI. And in some points, as long as the income doesn't meet a certain threshold, they can be eligible for both programs. It's typically better to be on SSDI because what that does, it exposes you to Medicare after an additional 24 months. And you can make more money depending on what you've paid in taxes in your employment history. There's another part of the SSDI analysis that's a little more complicated, and I'll just say that you have to meet a work orders requirement. And again, there's a dollar threshold, which is $1,510 in 2022. So you have, and there's timing associated with that, but you have to meet that requirement. On the SSI side, the monthly amount is set, and I think you see I can't see the number, but I think it's about $840 a month, and that's up to that amount. So that's the most you're going to get on the SSI side. And then SSI, if you're eligible for SSI, you're also eligible for Medicaid. Okay, applying for SSDI, including appealing denials. So there's a very, very low rate of approvals at the initial application stage. But to file for SSDI or SSI, you can go to your Social Security office. That's probably in this day and age, probably the best way to do it, because you can get somebody to sit down with. They can tell you what they need. A lot of times it's going to be, the more medical evidence you can provide on the spot, the better your case will be. And you might be a part of that 33% that might get approved on the first time. Or you can file online. Now, I've heard that filing online can be very, very cumbersome because first of all, you have to sit there for maybe 2 to 3 hours going through things, and then uploading documents and things like that can be very, very cumbersome. today, because we're coming out of the pandemic, the SSA offices, local offices have been closed to the public. They just reopened back in April of this year. And so during the pandemic, as you can imagine, there's been a lot of backlog. And so now that the offices are open, it's almost easier to get somebody on the phone, but when you're going to file, you need to really go in person if you're going to do that and try to make an appointment. That's what I always tell clients. Appeals, if you have to appeal it, you can also appeal that in person. You can file, you can do it online, or you can do it by mail. The recommended thing is, you know, with the appeals, because once you do appeal a decision, it just kind of goes in the ether, and you're kind of waiting for the SSA to respond to it. But the biggest key to it is making sure that you get it in within the 60-day time frame, and you also want to have proof of that. So oftentimes I'll tell clients, especially if they do it online, take a picture of it on your phone, of any confirmations that show that you filed it on a certain day, so that the Social Security Administration knows that you filed it timely. Of course, if you file it in person and you get a date stamp copy of your application, and that will also prove that you filed it timely. By mail can be kind of a toss-up, because I have mailed a couple of requests for appeals, reconsiderations, and they say they don't get them. I often use the receipt requested by the mail, by the U.S. Postal Service. And I'll get the card back and they'll still tell me they didn't receive it. So I think a lot of that is due in part to just, you know, lack of workers, the office being closed, and just being affected by the pandemic like everybody else. Now, it was slow before the pandemic, but it's really, really slow now. So the process for the way a application flows is you have your initial application, and as I said, it's a pretty low approval rate at that stage, so you're almost forced to request for reconsideration. Another good thing about the SSA website is that there are just a ton of forms that you can fill out. They're easy to fill out, and as long as you get that form filled out, and all forms have a number associated with it. So you would just fill out that form, file it within the 60 days. The notice that you get on your decision will tell you that you have 60 days, but they also tack on an additional 5 days, because they say you have to do it within 60 days, but we're gonna assume that you received this correspondence in 5 days after the date on the letter. So you technically have 65 days. I don't tell clients that. I stick to the 60 days. So that we have that buffer in case things are kind of running up against the deadline. Once you get a request for reconsideration, and if it's not, if it's adverse to you, then you can request for a hearing before an administrative law judge, considered an ALJ hearing. You also have to do that within 60 days. If after going to making your case before the ALJ, which quite frankly, before the pandemic was taking a year to get a hearing, at least a year. I don't know what it's like now. I think it's still slow. So, once you get that hearing and make that best case before the judge, you have 60 days if you have a unfavorable decision, and you can file that to what's called the Appeals Council, which will just review the record to see if the ALJ made any technical errors in the law. And then if you don't get a good decision with that, then you can go to federal court. So it's a pretty long process. So, I always tell clients, in order to really, really make your best case, you just want to put everything you have into the initial application. Sometimes it's nice to, if you can, write up a narrative or get someone to help you write up a narrative to show how disabling the impairment is. You really consider all those 5 steps that I mentioned before, and just make your best application at the initial phase. And that does one thing. It provides the Social Security Administration with good evidence to be able to say that you're disabled. And then it also builds the record for if you need to go forward, and you have the record right there. And quite frankly, it's a lot easier for a lawyer to help a client if they've done a really, really good job at the initial application phase. As I said, there's been some, these are common issues for all MLP clients. Again, there's been a big backlog. It's actually been very horrific. For all the good things that I can say about the Social Security's website, Social Security Administration's website, their response has been very, very frustrating, to say the least. As I said, they closed the offices during the pandemic. That did not stop them from sending notices for overpayments and things like that, leaving the claimants for, like, what do I do? I'm cutting off my benefits. I can't go to the office. I drop my documents in a Dropbox. They don't get back to me. But now that the offices are reopened, I'm encouraging folks to try to make an appointment for in-person discussion about their situation, whether it's an initial application or an appeal or an overpayment or anything like that. Another common issue that happens is a lot of times you'll be declared disabled, but the Social Security Administration will flag, or an ALJ, an administrative law judge will flag that disability and say that decision needs to be reviewed within a period of time, just to make sure that person has a continuing disability. This comes up a lot when, let's say, for example, a person is going through cancer treatment, and they can't, their situation is going to last at least a year, and they're going through treatment, but they were able to be successful in beating the cancer, and it's one of the cancers that can be that have a cure, high curability rate. And so if that's what the listing, there's a whole listing around cancer. And so if this is a cancer that can be reviewed periodically, then they will do that, and they will send the claimant a request to update their medical records. And after they've done that, if they don't respond, then they're going to probably be declared not disabled anymore. But sometimes they do respond with medical documentation, and they still say that they, based on this continuing disability review, you are able to work, or you should be able to. The most important thing about this is if you have a patient or a client that gets basically kicked off of SSDI or SSI, they should know that because they'll send a long letter, and buried in that letter are the appeal rights. But buried within those appeal rights is the fact that if you want to keep your benefits going, you need to appeal within 10 calendar days, as opposed to the 60. I mean, a lot of folks focus on the 60. Oh, I've got 60 days to talk to somebody about this. But if you want to keep your benefits going, you should appeal within 10 calendar days, and they should not cut off your benefits. Now, the risk to this is if you're found, if you make it all the way up to the ALJ stage, they could ask for that money back by way of an overpayment, but that rarely happens, because otherwise no one would appeal. Overpayments are one of the biggest things that I deal with, just because I just think it's really important when clients have this source of income. I want to keep, I have a really vested interest in making sure they're able to keep that money and do things like pay rent and all the other things that they need to live and take care of their families. So the way we deal with overpayments, it's, you know, traditional to the way you would deal with any kind of adverse decision. You will request for reconsideration. This is, again, a very slow process. I have a couple of them in the hopper, and for, you know, since I've been at actually I've been at CVLAS since January. I think I filed a couple of these requests very soon after I arrived, and when I checked on them, they still had not been considered, or they had not even been received, according to the Social Security Administration. I've had clients that had applied for reconsideration last year, and I've talked with, you know, trying to figure out the status of the request. They're still backlogged, and they have not been reconsidered. So it's not a fast process, but what you can do is request for a waiver. And there's no time limit on requesting a waiver, but there's two questions that are asked. Is it your fault, and can you afford to pay it back? And both of these have to be a yes. Well, it's not my fault, yes, and I cannot afford to pay it back. The Social Security is very, very finicky about whether you can pay something back. I've had them tell me, well, you know, if the person, even though the person told me that they were borrowing money from relatives and neighbors to pay their rent, the Social Security turned around and said, well, they paid their rent, so they can afford to pay it back. So they just overlooked the fact that the person had to borrow money to do that.
Oh my God.
So how can CVLAS help? So as Allison mentioned, we do work with clients, and all of these are on a case-by-case assessment, just because, you know, with the housing situation and you know, all of the things that CVLAS does around housing and other areas, it's just, you know, we have to be very, very discerning about the types of cases that we can take on. One good thing is that because these cases typically take a little bit of a slower route, I tend to take more of them if I can, like, plan them out. So, you know, don't hesitate to you know, at least ask the question, will CVLAS consider these types of cases? But we definitely can give advice and counsel on application denials, on adverse decisions, on continuing disability reviews, and sometimes even take those cases if we really think that there's good merit in saying to the Social Security Administration that these cases, you know, this disability is still in play, and that person should still receive SSDI. We can also provide direct representation and advocacy on overpayments, and that's, you know, I have gone to the Social Security office with the client to sit down and do personal conferences with the caseworker to try to at least understand how overpayments, how the overpayment came about. I will say that, you know, as we, you know, in this day and age, the Social Security Administration typically can get it right because they have so many resources around figuring out, you know, when folks are making money. And so a lot of times it's really not about whether or not you know, whether there really is an overpayment. It's really about understanding how it came about and trying to figure out what's the best way to deal with it. Because sometimes they will deduct, you know, from your, you know, they'll deduct a certain percentage from your payment going forward, which can, of course, lower your income. And then on children's SSI, we will take cases just because the private attorneys just will not take children's SSI cases. They follow a similar but kind of different path. They have a different set of listings. For example, ADHD under SSI is very different from ADHD under the adult listings, and how it affects children versus how it affects adults. So this is one that I scrutinize a lot more heavily, just to make sure that children's SSI cases are covered. Another thing is that, with children's SSI, it's important that they have it because they can get Medicaid, which opens up a lot more services to them. And the same with adults. I mean, you get Medicaid and you have a health insurance resource. So, so that's pretty much it. I have not been checking the time. I see I've gone over a bit, but I'm sorry. Are there any questions?
Yeah, thank you, Sylvia. No, that was great. A lot of information, and thank you for sending your slides. I will be sure to include those. I'm going to send an email to everyone afterwards with the slides and also the recording. If you all want to forward that to your colleagues who weren't able to attend today. We do have a couple of questions, Sylvia, in the chat. First of all, thank you. Maureen did post in the chat the components for demonstrating functional impairment for mental disorders. So thank you, Maureen, for posting that. And then we had a question, Sylvia, how does this work for children whose parents have worked for the necessary quarters and have paid into the insurance?
Well, they can, as long as, can you stop sharing, or can I stop sharing the screen? So
yes, so you need just hit the same.
Okay, all right. I'm sorry, I'm very used to Teams. Let me get everybody back. Oh, I still don't have it. Okay, so what was the question about? You said mental?
The question was, how does this work for children whose parents have worked for the necessary quarters and have paid into the insurance?
Well, they would apply, they would go through the same analysis. They can apply to get benefits through their parents' record. They have to be disabled. I'd really need to do a little bit more research before I give an answer, and I'm happy to do that. But generally speaking, they won't get as much as what the parents get, but they can get a percentage of the parents' earnings if they qualify, based on their own disability.
Okay, thank you. And then we had a question just about how to send referrals. And so thank you for asking that. I will also include in the email that I send out the link to our referral form. So we prefer that you send all referrals to the MLP directly, and then we will complete the intake, make sure we have the client's HIPAA form before we send over to Sylvia and CVLAS. So I'll include that in the email that I send to everyone. I don't see any more questions. I had a question for you, Sylvia. I know that we have a lot of folks on today who work with specific patient populations like sickle cell, the Ryan-White HIV clinic. So are there certain diagnoses or diseases where it's just easier or harder to meet the eligibility criteria? Are you finding that, for example, with either of those patient populations, are you seeing a lot of denials, or do you have any, experience in those areas?
It's kind of scattered. Most of my experience has been with like physical impairments. So, I mean, it's really, I would just go through the same analysis. I mean, it's kind of hard, I think, with, certain, and I don't know a lot about sickle cell in terms of I actually have never had a case with sickle cell. But I would go through the same analysis in terms of, how debilitating it is. And it's a very individualized, evaluation, because, certain people with certain impairments can still work and want to work, and others just cannot. So it's just really just a matter of just combing through the medical evidence and just making the case. I can't say whether it's any typical impairment, when you measure it against the listing, if it's likely or more likely to result in disability. It's just really kind of hard to say. Does that
Okay.
make sense?
Yeah, yeah, absolutely.
Yeah, I mean, I can distinguish, definitely it's harder for, like I said, physical impairments versus the mental, and a lot of times it's just hard, if you're going in under like, I'm sick and I'm depressed and I have anxiety, it's just, and you really, and those things are real for this, these populations, but sometimes it's just hard for the administration to, or at least they're going to say, it's just hard for us to measure how much anxiety is debilitating, how much depression is debilitating around that. So, I mean, you could have, your underlying impairment and all these comorbidities that exist with it. So you just really want to make it as an individualized assessment as you can. And, if your goal is to be approved for SSDI.
Hi, this is Marla, one of the patient navigators with the adult sickle cell team.
Mhm.
Is there a way to get the benefit award letter expedited? Because oftentimes we need that for housing or, especially for housing for recertifications.
Yeah. I would like to say, yes, but the unfortunate thing is it's just really, really hard to make contact. There's a compassionate, I've never used this, but there's a compassionate, I forget the exact term, but it's about, having compassion for what that person is going through that might, it might tip the scale in favor of disability, not necessarily expedite it. Again, the best way I think is to really, is to go in with all of your information at that initial stage, and just maybe try to develop a relationship with the caseworker and see if you can get it expedited that way. I don't know of any like fast tracking for claimants, just because the volume is just so high. I mean, that's why I wanted to show those statistics at the front end, because it is a lot of folks, and a lot of folks, I would imagine, during the pandemic have become sick because they had COVID, they had long COVID. And I think that's just, a lot of folks
Maureen, this is how.
are filing
Okay,
claims.
come on up. Just ring the doorbell when you get here.
Are filing claims and, are checking in on claims that, they had filed, during and prior to the pandemic. So I'd like to say there's fast tracking, but I don't know of a way to do that. I can double check and check with a couple of private attorneys and see if they know, and I can try to circle back to you on that.
Oh, no, I was speaking of the award letter, and I have created an account for a patient on the portal.
Mhm.
It's not working, or it won't let it email it to me, that kind of thing. So not as far as just applying for disability, just more so the actual award letter. They've already
you
been
have it.
approved.
Okay, I understand. I'm happy to check on that. I don't know the answer to that.
Okay. Yeah, someone had posted the portal, which I have created an account for patients to get it, but sometimes it's like it's not working, or they don't have access to email, stuff like that. So
Yeah,
but
that's what makes the online part difficult for a lot of patients. Yeah. I
But
get
then-
that, but I can check on that and see if there is a way. I'm sorry, I might have misunderstood your question, but yeah, that's a very good question, especially if I mean, I have a client right now who is, she lost her SSI, and she lost her housing as a result, but this all happened before I met her. And so it's just, again, it's a matter of like getting her back in before the administration, and trying to figure out whether or not she can file a waiver. It was an overpayment, which caused her to lose her SSI and then her housing. So I certainly understand how much of a problem that can be when you don't have that award letter. So the other part
Yeah.
too is getting paid.
So Maureen did post in the chat that you have to go to the SSA office in person and they won't fax it. Even if you promise to wait by the fax machine. So you do have to go in person according to Maureen, but you can get it the same day. And then it looks like, Maureen, thank you for, for answering
Yeah.
these questions. Do they accept walk-ins again or just scheduled appointments? And I think, and it's both.
Yeah,
and
and it's,
right
you,
now.
you need to, yeah, and it's each office is different. You know, you just have to call if you can, or go and see, you know, what the protocol is. I've had a lot of problems even before the pandemic in Chesterfield because you sit there forever, and that's kind of the, you know, it's not a good use of my time to sit there, you know, for 4 hours and not be able to even look at a cell phone in Chesterfield because they're very strict about things like that. So it's best to try to make an appointment or figure out how that local office operates. I've had, for example, good success in the Sandston office, which is a much smaller office. And some offices will pick up the phone. There's some offices where I have the number of one caseworker that I might be able to, you know, to get them to pry open something. So, you know, it's just, you know, just check with your local offices. I don't know what Richmond is doing these days. I'm about to find out. But yeah, good. Going in person now that we can is probably the best thing.
Okay, thank you, Sylvia. We are just at about time. So I want to thank you, Sylvia. This was great. Thank you all for participating. And I will send the recording with the slides and our link, our referral link, hopefully by the end of the week, this week. And I hope everyone has a great week.
Thank you, Allison. I'll send you the slides.
Great.
Okay.
Thank you all.